thank you everybody for joining us on Valentine's Day lunch break, or wherever you are in the world. There's obviously a lot happening right now in the world of compounding and medical weight loss and GLP-1s, all the things that we've talked about before. So we've done a couple of sessions in our office hours on medical weight loss and shortages and not shortages and FDA, and there's just so much happening. So we've been getting inundated lately with questions, as we often do, but more so lately because of what a lot of folks feel or are concerned about a coming deadline. So Julia is our resident expert on all things medical weight loss and GLP-1s. She works with, we work really specialized in the medical aesthetics community, as well as some other healthcare verticals, but really heavy with med spas and medical aesthetics and wellness practices. And Julia is like always our go-to resident expert on state regulations, and particularly in weight loss, lately, because this has been such a hot topic. So, Julia, thank you for letting me put you on the spot once again.
Yeah. Chris, I'm very invested in this case now, as we've been following it for the last 6 to 8 months. So we're watching every move and happy to talk about it.
Yeah, you were actually at the courthouse, I believe. You took a road trip from Austin to, where was it? Was it Dallas?
I did, to Fort Worth, and I was slightly disappointed because when I got there, it was about 20-30 minute hearing, and they kind of pushed a few things to where we see they are now, and it kind of makes sense. But not a lot happened at that. I think late January there was snow on the ground in Fort Worth, so it looks like that some more very important decisions are going to be happening in the next couple of weeks. I know it feels like we've been there before or thought that before about this case, but really reached a point where it can't go anywhere else. But there's, a couple of defined directions. So I think that at least is a little promising in what we can expect.
Yeah. So let's take a step back and then kind of just get people caught up. There's all sorts of talk, right? As far as medical weight loss in general, and then as far as compounding drugs versus not compounding drugs, and what is in shortage according to the FDA, the Food and Drug Administration, right? And then what is not in shortage. So what can people compound? What can't they compound? And then there's even different types of compounding pharmacies, right? The 503As and the 503Bs. Can you just walk us through, for people, most of our clients and people online probably know right now, what's gone on, but just give us a quick, couple minutes feel of kind of where we started and where we are right now.
Yeah. So first of all, I always like to direct people just to fda.gov and to their drug shortage database, because that's the best tool for you to, if you kind of get familiar with the terminology or what they label things, then it's a great way to keep yourself kind of informed about what's happening. So if you're on this, drug shortage database, essentially what you'll see if you search Tirzepatide injections or semaglutide injections in that search bar, you'll see, for example, that semaglutide injections are still currently in shortage, just so you know, right? So Novo Nordisk talking about Wegovy and Ozempic, that both of those drugs, the brand versions, right, are currently in shortage, and so compounding of semaglutide injections can still take place. There hasn't been a whole lot of news or controversy in that area, but just kind of cover that for one. And then Tirzepatide injections were recently taken off the drug shortage list. I believe back in October is when we kind of first started hearing about these grace periods and how that kind of timeline people would need to transition their practices off of compounded versions of these drugs. So now Tirzepatide injections are off the FDA's drug shortage list. It gets a whole lot more complicated from there because of the lawsuit going on between the Outsourcing Facilities Association versus the Federal Food and Drug Administration. So that's the case that we were kind of talking about in the beginning. That's in district court right now, in federal court in Fort Worth. But so kind of to take it back from there, we have two different kinds of compounding. I wouldn't call them both pharmacies, but it's two different statutes really that govern these, right? One is 503A, and that's your state license pharmacy or physician who's compounding. So that category is covered under 503A of the FD&C Act. And then you have 503B, that's our outsourcing facilities. So they're different. We can see that they're being treated differently in this case too, in the grace periods that the FDA has discussed. And we'll get into this, but kind of the FDA's previous guidance about the grace periods hasn't changed, even though some things have developed in this case. So we'll talk about that in a little bit.
So the OFA basically, I mean, kind of an obvious answer probably, but they basically said, compounding for these certain drugs, for tirzepatide, comes off the shortage list. OFA kind of jumped in and said, well, no, it's not, right? Or no, it shouldn't have come off the list. It should still be compounded. That's basically their argument at the end of the day.
Right. So the gist of their argument, and that's exactly the effect of it, is essentially their argument is that the Administrative Procedure Act, which is the APA, should have governed the FDA's actions in this case. It was a rulemaking kind of process that they should have given a notice comment period and had public comment basically as a part of this decision. And we definitely see that sentiment in a lot of the different, we see the basically the amicus briefs that are being filed. People are saying, hey, we have all these personal experiences. My patients can't reach the drugs at all these various pharmacies across my state. Seems like in reality, the drug is still in shortage. Why isn't that being considered by the FDA before they make this decision?
Right.
The FDA's kind of the background to that is that they have said, here are the bullet point things that we consider when we make this decision. A lot of that sometimes comes from the manufacturer's information that they're providing themselves. But the FDA has felt like these supply and demand issues are resolved enough to take tirzepatide off of the shortage list. So, and that kind of being the argument being related to the Administrative Procedure Act and federal law kind of leads us to where we are currently in the case, is that, and I can give some background on the case as well, but basically we're at a turning point where the judge, it's Judge Pittman in Fort Worth, wants to decide this as a matter of law on the APA, saying, look, let's review the process, whether this decision actually qualifies as something that would have required this notice and comment period, or is more adjudication. And so all of that, the court believes could be decided as a matter of law. And the judge actually suggested a motion for summary judgment a couple of weeks ago. And that's when I had gone to Fort Worth, and some of the parties were for that, some were opposed to that. The FDA was actually originally opposed to a motion for summary judgment, but I think now with some of the case background and the administrative record, basically, they completed that and it was released. And for whatever reason, now they are siding with Eli Lilly on moving forward with this motion for summary judgment. I think it's important to visit the grace periods maybe before I jump into, because I think that's really what people and our clients need to know. And then we can talk about why this case, why that might affect.
And on your comments of for people who, have not been through law school, right? Like when you talk about something being decided as a matter of law, I mean, that's basically just saying we're not even going to go through a whole trial in a case and hear this all, right? We're just going to kind of say on its face, we see what each side is saying. And in this case, probably plaintiff, right? We don't let OFA, we don't like what you're saying or we don't agree. So we're just going to kind of get rid of this thing.
Yeah, so motion for summary judgment, matter of law, because this whole case is kind of centered around this APA, the Administrative Procedure Act, which governs lots of federal agencies and not just the FDA, but essentially it comes down to this argument over, was this rulemaking or was this adjudication? And it seems very mundane, that distinction, but basically the fact that they didn't include the public on the decision, right. The FDA stated we didn't need to do that, and the judge is going to essentially review that process and decide that particular issue could be decided as a matter of law based on the APA, based on other case law that's been related similar type lawsuits with a similar argument about this
Right.
process.
Right.
So 100%. Kind of the effect there, though, think about it like a decision tree kind of branch, is that if this motion for summary judgment, which is now basically that's next on the docket, that's the next issue that's going to be decided in this case, it could be decided in whole or in part, and that's really important because if it's decided in whole and it's not a partial summary judgment, basically it's final, then that would mean it's appealable.
Okay.
Okay, appealable, that's helpful, because if the motion for summary judgment, if it's granted in favor of the defendants, and it's appealable, then that can go directly to the Fifth Circuit. Now, whether they take it or not is also a different kind of branch on the
Right.
tree, because
Right.
there has to be an issue of material fact. And so I can't speculate at all on what the like sentiment of the Fifth Circuit might be on this particular issue. But for example, if it's decided in part, then part of this litigation can continue because it's not final, it's not appealable. So it's could go in kind of like 4 or 5 different directions at this point. But I think what's important and it's definitely confusing is the issue with what happens to this preliminary injunction that's currently in place. And that's the language we see with regards to the grace periods, right? So the FDA released something, kind of they updated their statement a little bit on February 11th, so a couple of days ago, on these grace periods. So I'll just touch on those right now. For those who don't, it is definitely, it's timely because for 503A pharmacies, the grace period to continue compounding tirzepatide ends February 18th, 2025, which is this upcoming Tuesday, or until the date of the district court's decision on the plaintiff's preliminary injunction, whichever is longer, right? So I'm just going to focus on that and not really the March grace period, because the same concepts will apply. But essentially, our best understanding of this is that this hasn't changed. The preliminary injunction is essentially paused, but it's not dead per se. So their rule on this motion for summary judgment first, they could include the preliminary injunction with that and dispose of parts of it kind of that would make it moot. But basically, until we get to the end of the motion for summary judgment, that grace period, if you look at this language here, right, it's February 18th or until the date of the district court's decision on the preliminary injunction.
Right.
So we're waiting for something to happen to the preliminary injunction. It's not dead yet. It's stayed-ish, and it could be a part of the motion for summary judgment or not. And if it's not, and this is where it gets way more complicated, and the motion for summary judgment is in favor of the defendants and it's final, then the preliminary injunction is dead. It's moot at that point. So that's kind of just one example. And I think, I don't have a crystal ball, but I feel like that's a likely outcome here. And so what would happen then, in reality, if we're trying to plan out for, our clients and when can people really stop compounding this? Well, so they haven't released a date yet for when this motion for summary judgment, when the hearing is going to take place. And some of these filings also are not public yet. So we're going to try to keep people informed as much as possible. Again, my best prediction would be, we need to see those filings, and we need the parties to be able to answer the original filing or the complaint for the motion as well. So again, I believe that gives us about another month or so until that next hearing. And whether the preliminary injunction is included in that or not, it remains to be seen. And then from there, I think a lot of people, definitely the aspect of this that's appealable is important, but know that that's kind of a hard road to go down as well. So if the motion is granted in the defendant's favor, then there's got to be some issue of material fact in order for the Fifth Circuit to revisit this. So, and that's kind of that's of course, it's the really difficult part of our industry. It's so interesting. But uh, things kind of remain, they're getting clearer day by day because now we're like, okay, we understand that this can only really go in
Right.
these directions now. And I believe maybe the strategy there was, for Eli Lilly's short-term pain with extending the grace period for another, month or so, but potentially getting a final judgment in this case that may or may not be appealable. It's not
So,
automatically.
yeah. So kind of in a nutshell, what we're believing, right, is that so our clients, a lot of them have been reaching out like, what's this February 18th deadline? Do I need to stop? Can I continue to compound? And so our understanding, I think, kind of like Julia said, is that if you read the language of where the case stands right now, which you can, we find online and we can share with you, this is not legal advice. We should have said that earlier, but kind of just our opinion internally is the way this thing reads is that February 19th or 18th rather is not like this line in the sand and you can no longer compound after that. We're kind of watching because it's kind of the later of two things, right? February 18th or this other thing, and that other thing hasn't happened yet, and we don't know when it will. So people are a little bit, I feel like, on borrowed time. And so for our folks who are continuing to compound, I think the takeaway of all this, right, is like continue to think about your strategy going forward, and like once this does, if and when this thing does happen, and you can't compound tirzepatide, how do you pivot your business? But I think as it sits today, yes, you can. Our understanding, yes, you can compound it. As of February 18th, unless the court makes some drastic decision by then, yes, you can keep compounding. As we get further into February and then March, I mean, it's really going to be a day by day analysis. It sounds like. Is that an okay synopsis, you
Yeah,
think?
yeah, 100%. I think that we'll get more clarity when we see these motion for summary judgment filings, and I think the argument's not going to change. I think we're aware of that now, of what's being pushed forward, and we've definitely seen some interesting like amicus briefs in support of the OFA, and all of that is helpful. But know that right now, what the judge is really focused on is this issue with the APA. It's really not a matter of and for better or for worse, right? Like, but it is clear kind of what the argument is and what the
Yep.
focus is. And the focus right now is on the federal law. So I think that at least that provides some clarity for folks. And I do think we'll have some updates in the next couple of weeks. I feel like every time we talk about this, we're like, well, it's still unclear, but here's,
Yeah. Yeah.
what's, but that's the nature of the game with a lawsuit like this. I mean, if it was that simple, I think that we'd all be out of a job a little bit with
That's
yeah, they're progressing over time. The arguments are definitely getting more advanced in the terms of evidence people are providing, especially on the OFA side. But just know that this is very focused on federal law as it
right.
is. And so appealing that to the Fifth Circuit, it's got to be based on, again, a genuine issue of material, genuine dispute on the material fact
Yep.
about this. So,
And they're not, are there, we've had clients ask us about, an amicus brief, like they're no longer accepting
correct.
those, as you understand, right?
Right. The court has also made clear that they were no longer accepting those as of February 11th, when they posted the order on February 11th. So I think they're trying to move things in one direction, and that's really towards focusing on the content of the APA.
Okay. All right. Well, y'all might not have known it, but Julia is also our on the beat case reporter, and she's just following the court case. She said if it goes to New Orleans, she's happy to volunteer to go there, and to continue to follow this thing. I mean, it's wild in my mind. I'm like, is this going to the initially, is this going to the Supreme Court? Where does this land? I hate to tell everybody that it's still TBD. I think Julia hit on the head. Like it's kind of this decision tree, and
Mhm.
that's how we do our legal analysis. It's if this then that, and we kind of are at this place right now where the court's got a decision to make, a couple of decisions to make, and that's really going to dictate where we go from here. So we don't have firm answers, and I again think hopefully for people who are 24 minutes in, not like pumped to hear that we don't have firm answers. But I think like Julia said, we are getting day by day a little bit clearer of an understanding of like where this is heading, and soon enough, I think we will know, where we land.
Right. I think the takeaway is definitely, for the meantime, because there's no way that this issue is going to be resolved before February 18th.
Right.
Takeaway, the deadline is going to now, or the grace period is going to it's going to extend beyond that date until the preliminary injunction issue is decided, which may or may not coincide with when the summary judgment motion
Right.
is and when that is decided upon as well. If I
Okay.
had best guess, I would say that's not going to occur for another month, but we'll be keeping people updated on that.
Okay, that's great. Thanks everybody for tuning in, and hopefully it was somewhat helpful. Again, we've just gotten so many questions that we wanted to just pop on and give you the latest as we understand it. We'll continue to monitor, like Julia said, and of course, we answer all the questions as they come in as best we can. But definitely stay tuned, because there's just going to be a lot more coming soon, as this thing continues to unfold. And again, we literally have Julia in the courthouse as much as we can to keep everybody informed as soon as possible. All right. So thank you, Julia, for again spitting the knowledge. Appreciate you, and everybody who's tuned in.
You're welcome.